And our second tip is collaborative divorce right for me?
So I think I'll start with that one, Dustin, because I think that, given Melissa's description of collaborative, um, it's it's incredibly appealing for a lot of people, and a lot of it, and what I love about it most, from my perspective, is the skill building. So we as collaborative professionals feel very strongly about not only helping clients build durable agreements, but building those bridges to be able to function as a healthy family without any professionals. And so it's this two-step dance of building skills, teaching communication, sometimes retooling some of the unhealthy skills, but really focused on durable agreements that are their decisions. So that all being said, I'm sure lots of people are wondering, wow, is that right for me? And I've heard this question over and over again. The reason why I've heard this question over again is because of the disqualification clause, which is that main difference between mediation and collaboration. And the disqualification, as Melissa already described, is that the professionals step away from the matter if the matter falls into litigation. Sometimes clients say, like, why do we have to do that? The reality is that is the defining element of collaborative law. But also there's a reason behind that, madness, as someone might think. The reason is we're asking clients to be centered on their needs and their interests, which often creates some vulnerability in the room. And we can't then sort of have clients feeling, once they're vulnerable and problem solving and disclosing their needs and interests, that those same professionals are going to follow them into a more traditional litigation. So that all being said, we want to make really sure that when clients enter into the process, it's appropriate and that they have a high percentage success rate, that they will finish the collaborative process that they start. So is collaborative right for me? I would say I hope it's right for more people than not, but this is a different kind of problem solving. And so people, I think, who have the desire to sort of be in charge of their own destiny, desirous to sort of say, problem solve together on behalf of themselves, their financial situation, their children. A lot of times clients will ask me, I don't have a lot of trust in my spouse. Do I need a lot of trust? Do I need full trust? And they use that as a measurement to say, is this a process that could work for me? And often I think, if you're divorcing your spouse, it's unlikely that you have full trust in that person. You might, but it's not required. But I would say you need a modicum, some trust, to be able to kind of work through it. Because this difference is really the clients are making those decisions. Those monumental decisions are being made by the clients. The professionals are setting the stage and they're the guides. So professionals are giving options and their expertise and ideas, but it's the clients that are holding on to them to build that durable agreement. So we ask, do people have good problem solving skills? Are they interested in this sort of an approach? It is not necessarily easy. It can be challenging. These are difficult conversations that people are having, but we're setting the stage to make those difficult conversations a little bit more manageable. We're if somebody's concerned about, is this the right process choice for me? I think that we often use neutral, like someone like me who does sort of an assessment to help guide not only the clients, but also the lawyers. So perhaps we would do a neutral perspective would mean that the clients come in to do an assessment. Is it right for me? Particularly fact sensitive to their family. And so a neutral divorce coach and the lawyers might discuss the case prior to entering it into a collaborative contract. As ways to really help people discern whether or not this is the right process for them. What do you guys think, Karen and Melissa?
I think you hit the nail on the head. Yeah, absolutely. And, one of the, in my opinion, one of the great advantages with the collaborative divorce process is that it is a safe environment. It's private, confidential. You're not airing out your issues in court. Everything just stays, uh, you know, behind the closed doors amongst the professionals and the divorcing couple who are involved in the process. And they each party has their attorney by their side to advocate for them. So I think it's a wonderful process, for those couples who are on board with it, and for those couples where collaborative is right for them.
How is the role of the attorney different because in collaborative divorce, each person has their own attorney, right?
That's correct.
How is the attorney's job different in collaborative divorce versus like traditional divorce?
So in the collaborative divorce, we're there to, yes, provide them legal information, provide them legal advice, to be their support and backup, but we're not acting in an adversarial capacity. So we're there to make sure our client's voice is heard, but we're also there to make sure that it's not turning into a screaming match or a really unproductive type of fight. A lot of times in adversarial matters, the feelings and the anger is so entrenched in there that the parties are unable to make rational decisions. And in the collaborative process, because we have a coach who can help us to deal with that anger, we're able to then, as attorneys, be able to really get through to the clients. They're understanding that the decisions they're making is the right decision for them and for their family. Yes, we're working together as a team, but I'm still representing the interest of my client, and Karen's still representing the interest of her client. And we're not commingling that interest. My interest is not in the person who's at the other side of the table. I am taking care of my client and making sure that they're making an informed and best decision for them. So I'm still representing them and I'm still advocating for them away, but it's not in that adversarial process.
And can I just jump in here for a second, Dustin? Because I think for the way I kind of describe it to clients in sort of like what I'll call layperson's terms is, the difference between a position and an interest. So let's say traditional is more position oriented. That would sound like I want the house, right? It's a position. I want the house. It's attached to an outcome. In an interest-based negotiation, it would sound like I'm really interested in having a comfortable, safe home close to where the school is so the children can walk. So that would be an interest, right? It could mean the current house. It could mean the house around the corner. It could mean the house 2 blocks away. So, the lawyers and the other aligned professionals, the financial neutral, the divorce coach, the child specialist, they're all rooted in helping the clients discern what are the interests that would help them solve, rather than here's a position of what I want as an outcome. Now, please go get it for me. It's a different form of advocating.